specific guarantee only for a particular transaction. Continuing guarantee if a guarantee is given to a series of transactions. So it's a continuing guarantee. And if guarantee is given for an entire debt, then it could say an entire debt guarantee. Suppose a guarantee is given or the surety promises to discharge the liability of the principal debtor, and that promise is given to this creditor only for a partial debt, then you could say that it's a partial debt guarantee. But our section mainly focus upon continuing guarantee. So continuing guarantee means the guarantee which is extending to series of transactions. So when a surety guarantees to the creditor that he shall pay for whatever losses or how much this principal debtor is liable, if he is making some default, he will have to it, and that too in a series of transactions between them, that is continuing guarantee. And whether this continuing guarantee can be cancelled is the next question. So whether a revocation is possible with regard to continuing guarantee, is revocation is possible with respect to the future transaction by giving notice to the creditor. So surety can cancel or revoke from the continuing guarantee, especially with regard to the future transactions, by giving notice to the creditor. And suppose the surety dies, then of course it comes to an end. And suppose this principal debtor and creditor, they have entered into contract without taking any sort of consent from the surety, or there is some sort of variation in the terms of the agreement between the principal debtor and creditor, then too surety's role comes to an end. So surety is discharged when there is a variance in the terms of the contract, and that too without the consent of the surety gets discharged. In some case, you could say that the creditor himself will release or discharge the principal debtor. Then, of course, who will be discharged? Surety. That can be by either an act or omission from the part of the creditor. I'll just give you an example. Suppose Safia have promised to construct a building to Sharat. But Sharat says that he will supply the entire timber for the construction of the building. And I will be the surety. I am the surety for the performance of Safia. That she'll construct the house and I'll just look upon it. So I am the surety for which the Safia will construct the building. But there was an agreement that the entire timber will be supplied by Sharat. Sharat is the creditor, Safia is the principal debtor, and I am the surety. But Sharat has not supplied any timber. That means Safia could not complete the terms of the contract because the timber was not supplied to Safia. So there was an omission from the part of the creditor itself. That means surety is discharged. So creditors' act of omission may discharge the surety. So principal debtor is also released. He is also discharged. Safia is also discharged. She is also discharged. She is also released. That means surety is also discharged. So there can be such instances. Another instance is, in some cases, the principal debtor and creditor, they will compound the matter, settle the matter, and give some more time to pay the amount, or agrees not to sue. So when the principal debtor and creditor, what they will do is they will just make an agreement that they are settling the matter or giving some more time to pay the amount, and also not to file any sort of case. In that instance too, the surety will be discharged because he doesn't want to have any sort of play in that particular contract. He doesn't have any role to play in that particular contract. So that is with regard to the discharge of surety. Another instance, suppose the creditor is making a contract with another person and giving some time to the principal debtor, but surety is not discharged. He is having a role to play whenever there is loss or failure from the part of the principal debtor. Even if the creditor makes an agreement with any other third person or gives some time to the principal debtor, that means this particular surety is not discharged. Suppose there are more than one surety. So one of the co-sureties is discharged. That doesn't mean that all sureties are discharged. So if there are more than one surety, if one of the sureties are discharged, it means all other sureties are liable. So they are having the liability away. Suppose the surety pays the entire amount to the creditor and discharge the liability of the principal debtor. Then surety steps into the shoes of the creditor. So very important, section 140. So when the surety discharges the liability of the principal debtor, then surety will step into the shoes of the creditor. Then whatever the rights the creditor had, the surety will be entitled for all the rights and benefits that was enjoyed by the creditor, whether he knew all those things or not. Even if he doesn't know what were the rights or what were the benefits that is enjoyed by the creditor, this surety is entitled, is having the entire right of all the benefits that was enjoyed by the creditor. Now the creditor doesn't have any rule at all. Suppose this guarantee is given on misrepresentation or some concealment of fact by the creditor, then the contract of guarantee is invalid. So whenever there is misrepresentation or concealment, and likewise this contract of guarantee was entered, then the particular contract is invalid. Now another is implied promise. So as far between a surety and a principal debtor, there is always a contract of indemnity, because the surety is having the right to recover the damages, the payment, whatever he has paid from the principal debtor. So between the surety and principal debtor, there is a contract of indemnity. Surety is entitled to recover the compensation or whatever he has paid, where he has rightfully paid under the guarantee, not wrongfully paid. So whatever the surety has rightfully paid as a ground of this contract of guarantee, of course, he will have the entire right to recover from the principal debtor. So there is a contract of indemnity between surety and principal debtor. And when I said that if there are more than one surety, and if they are contributing equally, then they will be liable equally. If their contribution is actually shared equally, then they will have to contribute equally. So that is instance. Suppose if there are more than one sureties, and if there are different payments or they have decided different amount, then they will be liable to the extent of their liability alone, to the different sums, the sum that they will have to pay. So they'll be liable to according to their share of their contribution alone, not to the entire amount, only to their contribution, only to their part, only to the assured sum they have just promised. So this is a contract of guarantee. I'll sum up. So contract of guarantee is it's a tripartite relationship that's between the principal debtor, creditor, and surety. Surety is promising the creditor that he will pay the amount if there's a default from principal debt. And between the surety and principal debt, there's always a contract of indemnity. Whenever surety pays the entire amount, then he will have the role of the creditor. And he can recover the entire amount which he has paid in the contract of guarantee for the principal debtor. And if there are more than one co-sureties, each of them will be equally liable. In some cases, according to their sums or according to the amount they have fixed. So this is contract of indemnity and contract of guarantee.